The Honourable Vice President.
So let me just say this. As far as I understand it to be, in this Senate, there are guiding principles that maintains a high standard of debate, dignity, and decorum. This is only achieved by following process and procedure. I do not expect that I would have to repeat myself to a room full of adults. So let me say this once. For the rest of this fourth session, whether it be myself or Madam President, once we give a ruling, there's no line to dance on and there's no line to cross. There's only a whip, and we are not afraid to use it. This House will not be allowed to lower its standard in relation to dignity and decorum. We will follow that process and we will follow that procedure as the founding fathers outlined. Attorney General, continue.
Thank you, Mr. Vice President. Mr. Vice President, for the record, I mean no offense to my learned colleague, Senator Hussain, and we will press on from there. Mr. Vice President, I was making the point because I was invited, we as a Senate were invited by Senator Choate to be straightforward. And I was taking a very strident objection to Senator Choate's statement that we will not be blacklisted. And I was in the course of going through the material that we consumed to treat with this debate. I gave the context of the position that Trinidad and Tobago sat in as chair and deputy chair and outgoing chair of the Caribbean Financial Action Task Force and member of the SG group of the CFATF. And let me make it absolutely clear. In coming upon the obligation to have an action plan, which we were required to do in 2016, we were put into a one-year observation period by the ICRG group, and we were singled out because our economy is over $5 billion per year. And that being the case, Trinidad and Tobago found itself on public statements whilst we are in the International Cooperation Review Group. And those public statements are very precise. We found ourselves in a public statement alongside other jurisdictions. And the jurisdictions that we found ourselves alongside included Iran, the Democratic Republic of Korea, if I could call it, North Korea. We found ourselves along certain jurisdictions in Africa, etc. And coming out of a listing in that third round and fourth round mixed group, Trinidad and Tobago saw itself picked up by no less an entity than the European Union. The European Commission stepped out, the European Parliament stepped out. They misapplied, misinterpreted the publication of Trinidad and Tobago appearing on a list. And that list is where we are now. You're in review. You've committed to a working process. You have until June 2019 and May 2019 as it relates to FATF and CFATF. And being published on that list, the reality is that the European Union blacklisted Trinidad and Tobago. So I am astounded to hear Senator Choate say, in a very cavalier sort of way, that we will not be blacklisted. Because I'll say why. We are obliged to be assessed on the 23rd of April this month by the joint group of the FATF. Assessors coming from Canada, from Spain, from Mexico, a joint group of experts sits down with Trinidad and Tobago, goes against our action plan, and our action plan clearly states, as I have said openly to this Senate, September, October, November, December, January, February, March, April, 8 months I've been telling the Senate, not today, that we have to deal with this law. So this concept of being ambushed about the law and not knowing about deadlines, 8 months in a parliamentary cycle is a long time. It's nearly 1/5 of your time in the parliament, particularly when you go on a recess in the first week of July and you have the mandatory break. But the consequence that we will be facing is, as the first country to undergo fourth-round mutual evaluation. Let me repeat this. We are in uncharted territory as the first country about to be assessed by the international grouping, where the EU has gone off and misinterpreted ourselves, blacklisted us. The 190-odd jurisdictions in the FATF pot are looking to see which country is going to be crazy enough to not meet obligations for the first time. Have I put it as straightforward as Senator Choate has asked? Let me tell you what we come up to next. Jurisdictions subject, and I'm reading from the FATF public statement of February 2019 from their website. I'm reading from their publication. Here's what they say. Jurisdictions subject to the FATF call on its members and other jurisdictions to apply countermeasures to protect the international financial system from ongoing and substantial money laundering and financing terrorism risks. And then they go on. Here's who they published. Democratic People's Republic of Korea, and then they go on to deal with Iran. Both of those countries are blacklisted for failing to have graduated from the list. Do we want to be the next country in line alongside North Korea and Iran? With the greatest of respect to my learned senior counsel, Senator Choate, I am not taking the risk of advising this government as its legal advisor under Section 76(2) of the Constitution to accept any risk of failing the technical compliance procedures, because we will be the first country to do that. So let's get to this bill. Let's get to the concept of consultation. It isn't, as Senator Ramdeen put it, that since 2015 we were waiting on this. In applying recommendation 1 and in dealing with recommendation 8 of the FATF guidelines, recommendation 1 says do a national risk assessment. Recommendation 8, in treating with this NPO law, our mutual evaluation report published the fact, and I want to put it on record. They published the fact at 8.1, 8.4, 8.2, 8.2, 8.3, 8.5. Here is what our mutual evaluation report said. There are no laws requiring non-profit organization sector to be subject to AML CFT. Let me repeat that. There are no laws. Senator Choate made another very astounding submission to say there are laws to deal with unincorporated, because we know incorporated have laws to deal with them. Senator Choate said in a very forthright fashion that there are laws to treat with the NPO sector as defined. That is categorically wrong, honorable senators. And I will sit now and give way to anybody to tell me that it is otherwise. Anybody. I stand. It is categorically wrong. There are no laws. So you want to talk straight tonight? I'm going to talk straight tonight and set the record right. There are no laws because you're unincorporated. What could be binding you? It is not a law when you go to the bank and you fill out a bank mandate and you give 10 signatures. That is not a regulatory environment. That is not a law. and most respectfully in being very forthright tonight in talking about serious business for the taxpayers of Trinidad and Tobago, I'm being stern on the very good exhortation to talk straight tonight. So let's continue talking straight. In doing our risk assessment, we firstly had to go and understand who and what the NPO sector is. Do you think it's by mistake that we are able to stand up here and give you the precise number of NPOs registered under Parliament, in existence, coming under the state enterprises, coming under the social sector investment program? That didn't happen by mistake. That happened because we went to do the risk assessment and identifying who the individuals were. Therefore, we have precision now. The greatest risk exists in a lack of registration regime. It's the greatest risk. If you don't know who is in the pot, how are you going to assess the risk? That is why the first aim of this legislation is to say, register everybody. Register everybody does not mean regulate everybody. Register everybody provides a regime which is beneficial. You know who you're dealing with. You can certify the veracity of the registration because it's a public register. And Senator Deonarine, I will say, the public register falls under the Registrar General's Act, and you have access to that online as it is. So that's provided for in a different piece of law. It's the Registrar General's supervisory legislation that manages that. We have that. There's an online fee. There's not a fee for free because services cost. It costs $20 to access a file online from the pot of files if you want to search online, and it's no money if you're going to search during regular hours in the hard copy. So, greatest risk to sector, who is in the sector? This bill proposes that. This bill says let everybody register. Why? If you want the greatest chance of receiving charitable support, the outside environment is as important as the inside environment. The charitable benefits which are given under our corporation tax and other laws exist if you have covenanted deeds for charitable support. There's the write-offs that you get. But outside of Trinidad and Tobago, under, for instance, the Inland Revenue Service Codes, there's a section called the 501c3 status. When you develop the 501c3 status comparatives, if you achieve a comparator which is recognized by section 501c3 of the IRS code, you can get funding from charity purpose support from the United States of America. In other words then, you can access the outside world. Why do I know this? I have done it for years as an attorney at law for non-profit organizations and for free, in case anybody wanted to know, in the participation in that sector. So risk number one, we need to be registered. Mr. Vice President, may I ask you what time is my full time to end? Madam Clerk? Much obliged. Full time is 9:32, sir? No, 9:47 because of the suspension. Much obliged, 9:47. So first obligation, full registration. We propose in this law, in this bill before us, that we are going to ask a regulator to regulate the industry. We have elected the Financial Intelligence Unit of Trinidad and Tobago. That is an act of Parliament which created that. It's Chapter 7201 of the Laws of Trinidad and Tobago, Act number 11 of 2009. Section 18 onward deals under Part 3A, the supervisory authority. And when we get to 18G, we're dealing with the powers of the FIU. The FIU has a very precise methodology of regulating entities. It is a very administratively well-organized approach. You are to be regulated. How do they regulate you? They produce guidelines that tell you how you're going to be regulated. They produce directions. They go on an education program. They assess the risk of the sector. They then decide which aspect of the sector they want to deal with. And as Senator Vera put it, for instance, not all attorneys at law are subjected to FIU regulation and compliance, or under the financial obligation regulations. It's those dealing with companies or land or other aspects where terrorist financing or money laundering may be an exposure. Similarly, it's not the same for all entities and companies. So this bill, as we propose, says simply, register the Registrar General, let the FIU regulate you under Section 4, Clause 4. When the FIU is regulating you, let them produce guidelines. But Senator Vera very prudently recognized that we needed to do some expansion to the language. Because whilst I know from an understanding of the law that that's how the FIU operates, perhaps it could have been better expressed in this framework legislation. And therefore, we propose an amendment to Clause 4, which will specifically say two things. And let me deal with the argument of who should be regulated. There was very important mention today about who should be in the basket of regulation. First risk, we want everybody registered. Why? One single registry is the best way to approach. Secondly, somebody mentioned having three categories. Senator Richards, Senator Vera, Senator Deonarine, Senator Dial Singh, Senator Ai. We heard about what is the appropriate risk-based approach, Senator Choate. And there is merit, as was put out by the Law Association, in saying, well, okay, certain people beyond a limit should be regulated. Certain people beyond a higher limit should be further regulated. And certain people under the first limit should not be regulated at all. So, borrowing from the value-added tax regime, we have drafted an amendment for consideration. This will go into Clause 4 as well, which says that effectively, the regulator is going to regulate all registered non-profit entities except those entities that have a gross annual income under $500,000. So we're putting a bar to say, look, if you're an NPO and you have a gross annual income, for discussion, we're using $500,000. We've used the VAT formula for that. You're not in the basket of regulation. We then go on, importantly, in our circulated amendments, as you'll see on your table, to say where a non-profit organization is registered under this act, the regulator shall, using a risk-based approach, determine the level of supervision required for the non-profit organization under the Financial Intelligence Unit Act. I know that it was there, but Senator Vera was absolutely right. It needed to be put in more expressly clear language so that anybody reading that law who's not familiar with the interarticulation of laws would see it there. What does this mean? The FIU, in its rollout of the program, will decide what risk base is to be applied to the different categories, but it can't know the different categories until it has a registered list to then start to sift big from small, large from not so large, left from right, different types of charities, those that deal with children, those that deal with money, those that deal with other aspects. Clearly, a sporting club will not fit into it, a cake sale club, a homeowners association. We will only know that if we have one proper list. So here we are saying in Clause 4, accepting the recommendation to make the tiered approach, accepting the recommendation to be with clarity as to what the FIU will do, we propose an amendment to Clause 4. What do we do next? There was merit in saying that the Registrar General's use of approval of a name or renewal of the entity should be treated with. So, under the law, we say in Clause 7 that your registration lasts for 3 years. The question was, why 3 years? And the answer was, look, there's a 25% non-compliance in the industry. We want to help people out, but the risk-based approach says know your industry by making sure that you get knowledge. The best way to get knowledge is to actually say, look, renew on a periodical basis. So we're proposing that we shift it from 3 years to 5. Perhaps 3 years was too low. But when you jump back to Clause 6 is where the Registrar General may simply receive your application or your application for renewal and then the registrar may simply refuse or actually agree. And we felt that there was merit in the submissions coming to this House to say, look, if you're going to refuse, particularly because I may have been existing already, and insofar you have an opportunity to say no on the second occasion or third occasion, we're putting in terms of the circulated draft here that the registrar must give you notice, reasons in writing why the refusal is not being given, and then give you an opportunity to say why that shouldn't happen, then make a decision, and then you get your rights of appeal in clause 13 go forward. Now, even though it is administrative law in pellucidly clear fashion that the law is that the registrar would have to give you the reasons, we put it in here anyway. Again, out of an abundance of caution. So I'm not relying on the common law or the interpretation of the law. We are proposing that it be expressed into the law. Clause 7, as I said, we're going from renewal of registration from 3 years. We're proposing 5 years. We welcome submissions in the committee stage. Clause 10. We're saying in Clause 10, and Clause 10 treats with cancellation. In Clause 10, the first thing that we're doing, if I want to jump out at it, we're going to remove the reference to the cancellation happening because the regulator could tell you to cancel it under Clause 12. Why? Let's jump to Clause 12. We are proposing that we delete Clause 12 entirely. Clause 12 gave the impression that whilst you were under an administrative course under the FIU directions process, i.e. the FIU regulator under 12G, under 18G, under the FIU Act came in and said, look, take notice, do something, you don't do it, I'm going to court to compel you to do it. While that process is going, our Clause 12 gave the impression that the registrar could act without the conclusion of that process on a frolic of her own and cancel your registration. So we thought it prudent, let's delete Clause 12 entirely, and therefore let's consequentially amend Clause 10 and remove that reference. What are we doing again? We're saying, of course, that we should manage ourselves in Clause 10 only to these purposes, and therefore it is fair to do that because in 10.1a, there is a caveat there, without reasonable cause. That has been interpreted in law to be a very wide range of reasons as to why you didn't keep proper financial accounts or why you didn't submit your accounts. And that we feel is a very fair safeguard. I would point out the Companies Act does not have this language. We intend to amend the Companies Act because what the Companies Act is governed by is a procedure, a practice where the Companies Registry actually gives you notice by way of a query that your forms need to be fixed, etc. So we're formalizing the actual practice here. In subclause 2, we're asking for you, in clause 10, to give reasons why you should be cancelled. And again, we're going through show cause, give the reason why, and only then, we took Senator Aye's recommendation, only then are we going to say, at that point, exercise your right of appeal, which, by the way, is equal to the procedure under the Companies Act, by going to a judge. To hear Senator Hussain ask whether there's a right of appeal from the High Court to the Court of Appeal and to the Privy Council, that's axiomatic. That's just the law. I'm surprised that that question was asked of us, but for the record, I'll answer it in the affirmative as I have. Let's go to Clause 12. Of course, I've explained why we recommend we delete Clause 12. There should not be the ability of the registrar to delete, to cause the cancellation. Clause 14, we're proposing that we delete subclause 2. So let's get to 14. In 14, we're saying keep financial records. But in 14.2, we provided something which the NPO sector pointed out to us. And I'll name her, Roberta Clark, in particular. 14.2 said, a controller of a non-profit organization shall ensure that the financial accounts and records show and detail all transactions of the non-profit organization and disclose at any time with accuracy its financial position. the point that came back to us in our consultation with the NPO sector was, look, at any time means I have to be accurate every minute. And therefore, it's actually a higher standard than clause 15. There was merit in that approach. We propose that we delete that entirely because all that we need is the obligation in 14.1. 14.1 is the obligation to keep your records. And there can be no problems with that. When we get to 14, sorry, the next one is clause 17. In clause 17 was treating in this bill, and I said it in interruption, very kindly facilitated by honorable senators, that we proposed that the offense for failing to comply with 16 was inappropriate. We harmonized it with the Companies Act, which is to say there's an administrative fine, there's a penalty for failing to file your documents. We then go on after clause 17 to clause 18, and we are adding in clause 18 a very important safeguard. Clause 18 says in subclause 5 that a controller of a non-profit organization which contravenes 3 or 4, 3 is 6 months you shall distribute your property, 4 is that you must surrender your certificate, that we make it an offense and then we provide for it. Now that's a serious matter because if you still have your certificate, you can solicit money. If you've not distributed your property, you're breaching the provisions of the law, so there must be an offense. However, it is appropriate to put a qualification to the mens rea, and we cause that by way of a proposal to say who knowingly and without reasonable cause does that. So that leaves you the latitude for the less literate, for the institution with less capacity to say, look, I really didn't know. I was trying my best. My accountant was doing it. My lawyer was doing it. There was a reasonable cause to do it, and therefore we provided for it by an amendment to clause 18 as circulated. Clause 19, we're proposing be amended to take care of the suggestions raised by several senators, Senator Vera in particular. Now, clause 19 is where you should keep records. And what we've asked here is that we insert after subclause 2. So a controller shall keep records for a period of 6 years. What we wanted to do here, the first thing here, is to say, let's insert a new subsection 3. We'll renumber the old one as 4. Subsection 3. Where the regulator, in exercising its powers under Section 18G of the FIU Act, determines that a non-profit organization is not keeping the records required under this section, it shall issue a notice to the non-profit organization requiring it to provide records within such time as the regulator determines. In other words, then, you are not going to a strict offense. You're going to get notice from the regulator. The regulator says, listen, X entity, Y entity, you're not complying. We're knocking on your door and we're telling you, please comply. Obviously, the rest of Section 18G powers in the FIU Act can apply. If you don't do it, they can go to the court. They can ask for an order from the court. The court can deal with you by way of sanction. But we are providing that you don't trip this offense. You must have an offense. You must have legislative lines. We don't trip this offense unless you have had that notice from the FIU regulator. Very importantly, we are also adding the exception to what appears to be strict liability. Of course, it's not, pursuant to the Mauritius case in February 2019, as the Privy Council decided, in a different context, albeit in respect of conflict of interest. What we're saying here, we're adding again without reasonable cause, knowingly and without reasonable cause. We then go to a proposed amendment to clause 20. We accept the recommendation coming from all senators, in particular Senator Ramdeen. One point that I agree with Senator Ramdeen today, he was unusually caustic. He's not usually that way, but I accept we're getting into political season, so I understand the opposition's pointed attacks. We believe that we should harmonize the exclusions for persons to that which is in the Companies Act and slightly broader. So we're proposing that you should not be less than 18 years. Sorry, you should not be a child. Why? That's obvious because it'll become settled property, or you'll be offending certain aspects of the law as it relates to children. 2, you're disqualified if you're mentally ill within the meaning of the Mental Health Act. 3, if you're an undischarged bankrupt. But because we're dealing with terrorist financing and proceeds of crime, we've also added those offenses in. So we're leaving poker and Section 22B of the Anti-Terrorism Act, or if you're guilty of an offense under the NPO Act itself. So we're removing you have a charge for imprisonment. So that one steps out and takes care of the allegations that there are some charitable organizations that can do well with people who are reformed and participating in institutions. We then go to clause 22, and we're just harmonizing the language. Instead of saying that the forfeiture shall be in accordance with the legislation there, shall be treated in accordance with the forfeiture provisions, because it was important to harmonize that language. And we are deleting the last paragraph as it appears there. There was an inadvertent reference. Now that we have deleted subclause G, where we had the Section 12 cancellation, we've got to consequentially amend it here. We go to clause 23. In clause 23, we are dealing with the very important position of solicitation. So, solicitation, good point was raised by the NGO sector and by honorable senators. We have sought in treating with the solicitation to say, if you're soliciting without reasonable cause. So first of all, we're giving you that latitude from a mental intention point. Secondly, we're going to say that we should delete subclause 3. It is a defense for a controller. That's too narrow. So we've amended the mental intention in subclause 2, and we're saying specifically this section, this non-solicitation section, shall not apply to a person or group of persons who carry out a single event to raise funds for charitable purposes. So that takes care of the one-off occasions, etc. Now, we may go a little bit further at committee stage when we get there to provide a run-up to the wicket. My suggestion, which I'll ask the drafters to look at, and honorable senators can think about it, is that we ought to give people a 2-year grace period to solicit. Why? They may not know if they want to be in the non-profit dance or not. They may want to raise monies and see how they go, but they may not be yet in the game. It's something to think about. Providing for the one-off occasions, as we have, deals with a problem, certainly. Do we want to think about the 2-year run-up? It's something that the NGOs raised with me in our consultations in the last couple of days. There's merit in considering it. I welcome honorable senators' views on that particular perspective. Of course, clauses 13 to 28 will renumber appropriately, and we're proposing the insertion of a new clause 28. Very importantly, we say, and this ties into Senator Vera's point about making sure that the tiered approach for the FIU involvement beyond registration happens. And we say, in the new 28, it's titled Guidelines under Chapter 7201, that's the FIU Act. For the purposes of its functions under this Act, the regulator may exercise its powers under Section 18F to the Financial Intelligence Unit of Trinidad and Tobago to issue guidelines in respect of non-profit organizations. That gives them the full latitude to apply the appropriate jacket to the appropriate person, or the appropriate skirt to the appropriate person. We propose that we harmonize the regulations, etc., and deal with the consequential amendments numerically, 26, 27, 25. We propose again that we do some further tidying up for numerical references in the first column. We're treating with clause 3, clause 6, clause 10, 16, 17, 18 as renumbered, where we do the consequential amendments. So, honorable senators, there are easy fixes to this law. This law, let me put it quite simply, this law is not only important, this law is not only critical to avoid a blacklisting of Trinidad and Tobago, and I'll be very emphatic on insisting that I'm correct about that. This law is framework legislation. This law is to cause a registry to be created This law is to cause the FIU to be the regulator. This law asks, as we propose amendments, leave out people under 500,000. Regulate in a more stringent fashion people over 10 million in gross annual income. Treat with the persons in the bracket and those above the bracket, 10 million bracket, by asking the FIU to issue the guidelines and regulations as the FIU Act contemplates and as they in fact practice. And that way, we are making sure that we are taking a risk-based approach to a measured situation. Yep. So despite the complaints anywhere and everywhere, I am able to say the government can still state by way of an undertaking to this Parliament, because we have a committee of undertakings. We do not intend, as we do with every piece of law, to proclaim law until we go back out for consultation. That's what we do. That's what all governments do. That was the reason for the UNC coming to say why they wanted to repeal Section 34, which they proclaimed. Then AG said they consulted and the DPP said to repeal it. So this newfound surprise by the opposition is mystifying to me. Now, why did this bill come this way in the 45 seconds I have? This bill came this way because this government is faced with an opposition that quite simply says we're not supporting anything. At the committee stage in the House of Representatives, they said quite simply, take clauses 1 to 29 in one batch. Let the Senate deal with that. We're not supporting you. Go and check the Hansard. So I look for no support from the opposition bench. None at all. Their record speaks for itself. I will listen to their recommendations, pluck from it that which they don't want to give, and I rely heavily upon the independent bench because you know what? That's all this country has in Trinidad and Tobago today. This government, that independent bench, and then the noise of the opposition. Mr. Vice President, I beg to move.
Honourable Senators, the question is that a bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters be now read a second time. Those in favour say aye. Aye. Those against say no. I think the ayes have it.
A bill entitled An Act to Provide for the Registration of Non-Profit Organizations, the Establishment and Maintenance of a Register of Non-Profit Organizations, the Obligations of Non-Profit Organizations, and for related matters.
Leader of Government Business.
Thank you very much, Mr. Vice President. Mr. Vice President, I now beg to move that the Senate do now adjourn to Thursday, 11th April 2019 at 2:30 p.m. During that sitting, we will be concluding the committee stage of this bill.
Honourable Senators, before I put the question on the adjournment, leave has been granted for two matters to be raised on the motion for the adjournment of the Senate. Senator Mark.
Thank you, Mr. Vice. Mr. Vice President, I bring to this Senate's attention the recent termination of 7 industrial court judges by the government of Trinidad and Tobago, and what could be considered the loss of a combined industrial relations experience of over 100 years. Mr. Vice President, the industrial court has been under relentless assault and attack by the business community, by the chambers of industry and commerce and energy, both of them in particular. and they have been undermining and contaminating the environment insofar as the industrial court is concerned. So, Mr. Vice President, it was not surprising that the employer class would have reached their plea, their cries, would have reached the ears of the government. And the government has decided to undermine the balance in the industrial court. Mr. Vice President, would you believe that there were 5 vacancies at the industrial court for almost about 3 years? People have died, former judges. The government never chose, Mr. Vice President, to replace those judges that have passed on. So there were 5 vacancies. But you know what the government chose to do, Mr. Vice President? When the appointment, when the contracts of 7 judges came to an end in this year, rather than the government took the decision to fill the 5 vacancies, which are still available as we speak, they chose, Mr. Vice President, not to renew the appointment of 7 industrial court judges. What was even more alarming, Mr. Vice President, is that you would believe that these judges that are being appointed, the new ones, would have at least be given the dignity and the relevant protocols observed by the government. Because you're talking about judges, Mr. Vice President, who have to sit in judgment. They sit in the courts to make determination on matters that are before them. Their instruments of appointments would be issued and handed out by Her Excellency. But you know what this government chose to do? In the most reckless and irresponsible of ways? The Attorney General, Mr. Vice President, who is the person charged with the responsibility under the Industrial Relations Act to take to cabinet new appointments of industrial court judges. What the Honorable Attorney General did, Mr. Vice President, in accordance with the newspaper of the Trinidad Guardian, dated April the 2nd, there's an article, Mr. Vice President, that reads, Cabrera among 6 for industrial court. And it went on to say, Mr. Vice President, that the Attorney General, Faris Al-Rawi, confirmed the appointment during a press conference at the Attorney General's and Legal Affairs Tower yesterday. So, Mr. Vice President, even if you decide to get rid of 7 judges and you appoint 7 new ones, the Attorney General of this country did not even have the courtesy to allow the President of the Republic to handle the instruments of appointments. What the Attorney General did, in fact, Mr. Vice President, was to hold a press conference to announce the appointment of these 7 judges. And the instruments would then be handed to the President after the announcement would have been made by the Attorney General. Mr. Vice President, this is an untidy and messy affair. You must have respect for office holders like industrial court judges. You don't treat them in the way that they were treated by the Attorney General and by the government by extension in Trinidad and Tobago. But, Mr. Vice President, under this government, the industrial court was seen as being one-sided by the employer class. They sell that message to the government, and the government bought it lock, stock, and barrel. So what the government has done in return, they have appointed 7 judges, Mr. Vice President. 7 new judges. And, Mr. Vice President, if I may call their names, Lawrence Achong, he has been reinstated as the chairman of the Essential Services Division. But the new people on the block in the court, Angela Hamill-Smith, a member of the General Services Division. She comes from Massey Group of Companies. Employer. Indira Rampasad Sweet come from the employer class. The other one here is Elizabeth Solomon from the employer class. The other one, Nizam Khan, employer class, whether it's government or private, doesn't matter, employer. And then there's one, Mr. Vice President, called Mrs. Wendy Ali, former Chief Executive Officer of the Northwest Regional Authority, and Vincent Cabrera, the Lone Ranger. The Lone Ranger. So out of 7 judges that they have appointed, Mr. Vice President, only 1 person came from the trade union movement. Only 1 came from the... So, Mr. Vice President, I raise this point to indicate that the government has invaded the industrial court, they have subverted the industrial court, they have employed their own friends in the industrial court, they have created an imbalance in the industrial court, and Mr. Vice President, that is not good for peace, it's not good for stability, and it's not good for our economy. I thank you, Mr. Vice President.
Mr. Vice President, may I first of all say that there is a particular odium to be had by castigating people that go to do judicial service in this country. And first of all, this government takes no advice from members of a party that could appoint Reshmi Ramnarayan to the sensitive office of the director of SSA. I want no advice from Senator Wade Mark, who had nothing to say when a telephone operator entirely unqualified to be in the post of director of the Strategic Services Agency could have been appointed. So let me start with that. Trinidad and Tobago is a cosmopolitan, beautiful country. The industrial relations environment requires us to do a revision of our laws since our IRA legislation has some antiquity attached to it. But we also have the benefit of a quite developed jurisprudence in the industrial court. It is important not only to develop the laws, but to gain perspective on the laws. This cabinet has acted pursuant to the Industrial Relations Act. It is the president, by virtue of the cabinet's direction, that appoints members of the industrial court, other than the president, who is appointed pursuant to the Judicial and Legal Services Commission. That's trike law, Mr. Vice President. And Senator Mark, who wears the garb of a trade unionist, perhaps ought to know that, Mr. Vice President. Because again, Senator Mark was fingers on lips, entirely silent, while the UNC government proceeded in restacking the court in whichever way it saw fit. And there's nothing wrong with that. What I find offensive is to hear Reshmi Ramnarayan type appointees now come to tell this government that Angela Hamill-Smith is to be poured into some degree of scorn because she served in Massey Holdings. that Indira Rampersad Sweet, who comes from the Board of Inland Revenue, is quote-unquote private sector. To hear that Elizabeth Solomon, who sat at the United Nations, who developed the arbitration laws of Trinidad and Tobago, is to be found in some degree of odium. To hear that Nizam Khan, who by the way is a magistrate, and who by the way was appointed by the UNC government on the last occasion and now returns again, that all of a sudden Nizam Khan is not good enough to sit in the industrial court. Further, Vincent Cabrera, Lone Ranger. Mr. Vice President, can anyone take anything Senator Mark says seriously? There's a cloud of doom and gloom over the entire opposition bench. Everything bad, everything terrible, everything is odium, everything is suspicion. You see, do so don't like to say so. And what they like to do, Mr. Vice President, is to basically deprecate every institution that has sanctity in this country by dragging it into odium and suspicion. On behalf of the honorable members now recommended by this government to serve as judges, I wish to apologize that this matter on the adjournment could have been treated in the fashion that Senator Mark treated it, where he could deprecate the bona fides of decent citizens in this country who have given their service to industry, to private sector, to trade union, to the judiciary. I take offense to this matter being dragged into the proverbial mud, the political mudslinging that the UNC brings to this parliament. And I thank you, Mr. Vice President.
Senator Mark. Mr. Vice President, the second matter I want to raise is the invasion and politicization of the judiciary. Mr. Vice President, you would know that we passed a law, I think it's called the Criminal Division Act and Traffic Courts Act. We warned this country that this act and some of its provision would have severe consequences for the judiciary. And Mr. Vice President, so said, so done. It has come to pass. Mr. Vice President, you would have read, and the whole country would have witnessed over the last period, where workers of the judiciary have had to be protesting, praying, demonstrating in front of the Hall of Justice. What are they demonstrating for, Mr. Vice President? They are fighting for job security. You know why? Because the Attorney General brought legislation here purportedly to deal with the backlog in court matters. And in doing so, Mr. Vice President, he has reformed the judiciary, restructured the judiciary in order to facilitate that objective. But in restructuring the judiciary, Mr. Vice President, what the Attorney General has done in this legislation is, in fact, created and at the same time remove permanent workers and consequently replacing those permanent workers with contract workers. That is what the Attorney General has done. And Mr. Vice President, these reforms are expected to take effect sometime, I think, on September the 1st, 2019. The Public Services Association, representing the workers there, has stated publicly that the restructuring process is expected to affect over 400 workers who currently hold acting appointment within the judiciary, while some 200 others, Mr. Vice President, will be reassigned to ministries and other state bodies. Mr. Vice President, these proposed changes to the structure of the judiciary came about, as I said, because of the passage of a bill, which is now an act, called the Criminal Division and District Criminal and Traffic Courts Act, Mr. Vice President. Mr. Vice President, even the judiciary has had to admit that some of the current jobs in the judiciary would become redundant under this piece of legislation, and that will start kicking in from the 1st of September, Mr. Vice President. Those jobs would include clerks of the peace and assistant clerks of the peace, Mr. Vice President. Mr. Vice President, what this would mean is that the government is going to be utilizing new opportunities to employ persons within the judiciary, not on the permanent establishment, but on contract, Mr. Vice President. And when you employ workers on contract, their job security becomes more insecure and their future becomes more shaky, Mr. Vice President. Even a high court judge, Justice Gobin, has gone on public record as it relates to her expressing concerns for the security and the future ability of her staff to serve her as a judge in that particular area of the court, Mr. Vice President. So what I am dealing with here and what I've raised on behalf of the United National Congress is what appears to be an infiltration. The Attorney General talks about bringing down institution, bringing institution in disrepute. Mr. Vice President, the action taken by the government of Trinidad and Tobago by restructuring the judiciary and by getting rid of permanent staff and those who are acting, getting rid of them and replacing them with contract workers, Mr. Vice President, that will have long-term effect on the stability of the judiciary. And you're talking about, Mr. Vice President, contract workers who will now be beholden to who? Who is going to appoint these contract workers? Is it going to be ultimately the cabinet, Mr. Vice President? Because any job you want in the public service and in this place called the judiciary on contract, it must be approved by the cabinet. The JLSC cannot create jobs, Mr. Vice President. They must get the approval of the cabinet. So the political directorate will have a direct and indirect influence over the employment of staff at the judiciary. And Mr. Vice President, I am worried as a member of Parliament and as a citizen of this country, when you put the politicians, when politicians are involved ultimately in the appointment of staff in the judiciary, it is a violation of the space between the executive and the judiciary. It is a breach of the separation of powers principle, Mr. Vice President, and it is wrong. And that is what the government has been doing. And they have been invading, and they have been subverting, and they have been contaminating the whole process, Mr. Vice President. And therefore, we are saying to this government, you cannot continue along that line because you won't be there for long. We will have to come and revisit what the government is doing. Mr. Vice President, it is my view, and it is our view, that the judiciary should have a permanent cadre of workers. They should be on an establishment, they should be permanent, and they should be public officers. They should be public officers, and they should be insulated from political influence, either directly or indirectly. And what the Attorney General is doing is, and the government is wrong, Mr. Vice President, is messy, and is going to have long-term consequences for this country in terms of the future of justice in this land. So I bring this matter to the attention of this Honorable Senate, and to also ask, Mr. Vice President, for consideration to be given for a review and a reconsideration of this road or this route that the government is traversing and traveling at this time. The government should meet with the Public Services Association that represent those workers and seek to find some arrangement so that, for instance, the workers can have job security and there would be no contract for those workers who work in the judiciary, Mr. Vice President. Those workers should be permanently employed and they should be on the establishment on a permanent basis and not have people, Mr. Vice President, on contract for 3 years. And then your contract will have to be renewed every 3 years by who? The cabinet indirectly of Trinidad and Tobago. So, Mr. Vice President, it is not a proper approach to the judiciary and providing it with the resources that ought to be provided at any rate, but it should not be where the government, the long arm of the state, the long arm of the government, Mr. Vice President, has now reached into the judiciary. And that is a danger that our country faces, and we must expose it for what it is, Mr. Vice President. It is wrong, it is messy, and it should not be continued. And I call on the government to meet with the Public Services Association with a view of urgently addressing this matter and to dump and get rid of this whole approach that they are taking to put workers involved in the judiciary on a contract and on a contractual basis. Mr. Vice President, I thank you very much.
Attorney General.
Mr. Vice President, it is a genuinely, excruciatingly difficult exercise to listen to Senator Mark's intellectual contributions. And let me say why. Not only does he constantly repeat the same thing over and over again in the definition of what is ad nauseum, but Mr. Vice President, how do you take a submission like that seriously? First of all, where does the government have a role in treating with the JLSC? Secondly, this government and this dangerous part, and we demand contract be removed, and we have public service. But what did the UNC do for 5 years and 3 months about that? What did Senator Mark, when he sat as the Minister of Public Administration, do about that?
Nada.
Mr. Vice President, Senator Amin, when we did the Family and Children Division, took great pride in saying, "Y'all bring back our bill. That was our work. All hail Kamala Prasad Bisesa." That was effectively what she said, the Honorable Senator. Song and dance and gallery. Mr. Vice President, you know what's in that bill? You know what's under the authorship if you accept what Senator Amin has to say? The same provision for contract workers. So, Senator Mark didn't know that the Children and Family Division Bill created 2 categories of persons, including contract workers. But yet, sitting a couple chairs to his left, Senator Amin is boasting that they have quote-unquote maternity of the legislation. I mean, come on. Come on. Intellectual dishonesty and laziness in a perfect combination of nonsense. That's what that really is, Mr. Vice President. Mr. Vice President, there are 452 persons employed in the magistracy. For the record, the legislation, which is the criminal division, is intended to expand the judiciary. We are not seeing the judiciary in its negotiations with the PSA, because the government has no role in that. The judiciary, in their negotiations with the PSA, are treating with the following statistics. Of the 452 persons, 13% are OJTs. 12% are Ministry of Labor assigned on 3-month contracts. 37% are temporary clerks who do not hold appointments in the public service. 11% are on contract. 5% hold permanent and pensionable positions in other parts of the public service. and 22% hold permanent and pensionable positions in the judiciary. What kind of insanity is it to suggest that permanent pensionable positions under the judiciary and the public service, and if you add it up, is a whole 27% of the 100% are going to be sent home? What insanity could that be, Mr. Vice President? Because contrary to what Mr. Senator Mark is suggesting, the judiciary is expanding. Now, for the record, nobody is being made redundant in the position of clerks of the peace. The vacant posts for clerks of the peace, which have nobody in it, are being made redundant. In other words, then, an hypothetical position in which nobody is placed is being dealt with. And why? Because, Mr. Vice President, when we created the Family and Children Division, the criminal courts, and the criminal division, we recognized that clerks of the peace were breaking the Legal Profession Act. The clerks of the peace are not attorneys at law, and therefore when they give legal advice as they do, they are breaching the Legal Profession Act. But more particularly, Mr. Vice President, none of the clerks of the peace are going home, because there has been creation of a specialized position for them. And for the record, none of them are in fact permanent as far as I'm aware. They occupy other substantive positions. So in this dance, the PSA technically represents 5% of the judiciary, because they don't deal with the permanent and pensionable positions in the judiciary. They're dealing with the public service. So of that 5%, we are witnessing a sitting politician, that is Mr. Watson Duke, rallying people openly described as contract workers to frighten them up and down. Mr. Duke has announced to the world that he intends to leave the PSA. We'll wait and see if that ever happens, because he's taken a full-time role in politics. Mr. Duke is the kindred brother to the UNC. And Senator Mark has the audacity to say that this government is playing politics in the judiciary and attacking the judiciary, when the only attack that could be found day and night comes from the mouthpieces in the UNC. So, Mr. Vice President, in short thrift, intellectual laziness, intellectual ill-preparedness, devoid of merit, devoid of research, devoid of truth, devoid of diligence, are the phrases that one can use to describe the motion before us in terms of research. It is designed to create fear and pandemonium to suit the UNC's particular purpose, because they are in a state of panic that the criminal justice system has improved, that maximum sentence indicators are happening hundreds at a time, that the first judge-only trial for a murder case happened in this country with an acquittal. It was the same UNC bench, Senator Saddam Hussein, Senator Gerald Ramdeen, that said, who in their right mind on a murder charge would go before a single judge to have a trial? Yeah, you weren't here for judge only. Oh, I apologize. Senator Ramdeen was. I apologize to Senator Hussein. The fact is, the UNC bench echoed a chorus that nobody in their right mind would use judge only. What I can tell you, introduction of criminal proceedings rules, divisions of court, removing court blocks, dealing with improvements in the IT technology, expanding the judiciary, and making sure that we hire more people via the Judicial and Legal Services Commission, because we intend, Mr. Vice President, I should add, to amend the Judicial and Legal Services Act to allow that entity to do the hiring of what the public service normally does. Judicial research officers, judicial support officers, specialist categories ought to be done by the Judicial and Legal Services Commission. So I reject out of hand the insanity that was presented under cover of a motion, and I thank you.
No, Senator Senator Mark. Senator Mark. Honorable Senators, the question is that this Senate do now adjourn to Thursday, the 11th of April, 2019 at 2:30 p.m. Those in favor say aye. Aye. Those against say no. I think the ayes have it. This Senate now stands adjourned to Thursday, the 11th of April, 2019 at 2:30 p.m.